We're back with Right to Life Radio, and I want to talk about, I think this is, there's a couple of topics that I get all the time. All the time. Being Mr. Pro-Life, people will ask you, what do you do? I work for Right to Life Central California. And there are a lot of people in the Valley who know of Right to Life, support Right to Life, and when they see me, they know I'm like the radio guy, they know I'm Mr. Right to Life, and they talk with me and they ask me questions. And often they will ask me a couple of key questions that I hear very often and very repeatedly. And I want to address some of them because I'm sure if you're listening to this and you're like most of the people I've met, you probably have those same questions. So one of the big questions I get this very often from other conservative men who support the cause of life or from the broader audience in general, is the question of how did it happen that men have absolutely no role in the abortion decision? How did that come to be? Or do men have any role in the abortion decision? Can a father of an unborn child have any say whatsoever over the decision to abort his child? Now, for a long time, prior to Roe v. Wade, the simple answer to this question was, as far as what the law is, no. Men had, under the Roe v. Wade and its subsequent Planned Parenthood versus Casey legal regime, men had absolutely no rights when it came to the question of abortion, even for their own child. Now, why is that? Well, the way the Supreme... Now, this has to do with sort of the broader question of how Roe v. Wade came about. Roe v. Wade was issued by the Supreme Court, and it was the Supreme Court purporting to be interpreting the U.S. Constitution. They say the 14th Amendment of the Constitution, and maybe a couple of other parts of the Constitution, contain hidden within it a right for women to have an abortion. And they lodged that right with women, with women's ability to make choices, whether it was part of the liberty protected by the 14th Amendment. 14th Amendment has the famous Due Process Clause, which says no person shall be deprived of life, liberty, or property without due process of law. And the idea was that this is part of the liberty that women have to choose whether or not to continue a pregnancy. A very anachronistic approach, I think, to a provision of the Constitution written in the 1860s when nobody thought legal abortion was a thing. Now, but basically the idea was the Supreme Court said, no, that's what the Constitution means. And the Constitution's kind of like the foundational law of the United States of America, okay? You can't pass a normal law, a majority in the House, majority in the Senate, and the president signs it. You can't pass a normal law like that if it contradicts the Constitution. It wouldn't even structurally make sense, okay? So if let's say Democrats controlled the House, Senate, and the White House, and they passed a law saying, we abolish the right to freedom of speech for Republicans. Well, that wouldn't even make any sense, okay? The whole point of putting the right to freedom of speech in the Constitution, one of the larger points of the Bill of Rights is that it's supposed to protect politically unpopular people. It's supposed to protect people in the political minority. You don't need to have a constitutionally guaranteed right to freedom of speech unless you're saying something that most people don't like. You don't need a constitutionally protected right to free exercise of religion unless you practice a religion that most of the rest of the community doesn't like. Okay, so a lot of what's in the Constitution is counter-majoritarian. It's protection for minorities, opinion minorities, speech minorities, and in some cases, racial minorities. So it wouldn't make sense for the relatively small majority you need to get a majority in the House, majority in the Senate, and the White House, just to overrule that with a simple law. Okay, so normal laws have to be consistent with the Constitution. The Supreme Court says the Constitution means this, that women have a right to abortion. So because of that, no state legislature, like California's legislature, the Assembly, the Senate, the governor signs a law, or Congress could pass a law abridging a woman's right to have an abortion. And the way that the court framed this in Roe, but more importantly, in subsequent cases, like Planned Parenthood versus Casey, they basically said that this right is lodged with the woman, not with the dad. That it's her life that's chiefly burdened by a pregnancy, her body that's chiefly burdened by a pregnancy. In fact, Planned Parenthood versus Casey was a case. So this was a Supreme Court decision that it was in 1992, and it wound up people thought in 1992 the Supreme Court's going to overturn abortion. This Planned Parenthood versus Casey case, this is what it's going to be. And this was a case involving the plaintiffs were Planned Parenthood of, I think it was Planned Parenthood of Southeast Pennsylvania versus Bob Casey. Bob Casey was the pro-life Democrat governor of Pennsylvania. Very prominent Democrat and kind of would be a very odd duck today, a pro-life Democrat who's a governor of a major state. And Casey passed a law called the Abortion Control Act. And basically, he passed this directly to be a challenge to Roe v. Wade. One of the provisions in his law was a requirement that a husband would have to give his consent before his wife could abort their child. And the Supreme Court in Planned Parenthood versus Casey threw that out. They said, no, if you do that, it places an undue burden on the woman's constitutional right to have her abortion. Even if it's something where the husband would just be notified, that's too much. That puts too much of a burden, too much of a risk, too much of a condition on this constitutional right that women have. So the court just had no sense that men had the Supreme Court interpreting the Constitution, having the last say on what the Constitution means, thought that men just had no role in this whole thing whatsoever. And so as long as Casey remained the law of the land, and Casey effectively remained America's foundational law when it comes to abortion from 1992 until 2022. For 30 years, no state could ever pass a law giving a husband or a father any kind of say, any kind of veto power, certainly not any kind of veto power, and couldn't even require that he be notified prior to his wife or the mother of his child, whether married or not, having an abortion. So that has been the status quo. That is the status quo still in California. But we just had a major change last year, the Dobbs decision. So in Dobbs, the Supreme Court said, the Constitution just doesn't have anything to say about abortion. It's not a protected right. It's not explicitly in the Constitution, and there's no history or tradition in America of a right to abortion being recognized as something that's foundational to our American concepts of ordered liberty. No one had any idea of abortion as any kind of right until the 1960s. So, no, it's not in the Constitution. It's not something that's inherent in the 14th Amendment, which was ratified after the Civil War, or anywhere else in the Bill of Rights, ratified in the 1780s. So, as a result, you could today see a state pass a law saying a biological father has to give his consent before a woman can have an abortion. A biological father has to at least be notified before a woman can have an abortion. I think states today now have pretty broad latitude. If they wanted, they could pass a law like that. Now, is that the wisest thing to do? Well, this is kind of the difficulty here. Obviously, we as pro-lifers don't think anyone should legitimately be allowed to choose abortion. We don't think anyone should be allowed to choose to end another human being's innocent life. So it almost, I think, is kind of a side question whether husbands should or shouldn't have veto power. No one should be allowed to have the right to abortion. So, I mean, it's not like abortion's okay if the husband's okay with it. And in fact, breaking through this illusion of choice, a lot of times women are choosing abortion due to spousal pressure, due to their or intimate partner pressure. often it's men exerting, whether sometimes explicit, sometimes coercive, but many times either implicit pressure or explicit pressure that I don't want to have this baby. I'm not going to, I don't want to have this baby. I don't want to support this baby. I don't want you to have this baby. And maybe a threat of ending a relationship or whatever it is. Very often, I mean, it is a not insignificant percentage of women who are choosing abortion in part because they don't have support from their partner. So I guess it's kind of a difficult question to ask, well, should men have a say in the abortion question? Obviously, you wouldn't want a man necessarily to have a say if he was a rapist or engaged in spousal abuse. But at the same time, we don't think necessarily anyone should be allowed to legally kill another human being. So it's kind of a thorny issue. I think most pro-lifers are probably wise to think about it more in terms of, hey, no one should have a right to end a child's life, so let's work towards that goal. But I do think there's some issue of justice here. Why? Because, we see through our Rachel's Vineyard ministry and in other ways, men who had no say in the life and death of their own, in the death of their own child, who are left feeling completely powerless, and this horrible injustice that they suffered of their own child being killed, and they had no legal recourse. They had no ability to stop it. So it's kind of a difficult issue for us as a pro-life movement. Like, what policy should we seek? I mean, it's kind of a difficult. I hope you all can see that this is kind of a difficult and somewhat subtle issue. All right, we'll return with a couple more little evergreen questions when we return. This is Right to Life Radio on Power Talk.